And so before the court today is the PRA scheduling conference for this Public Records Act case. First of all, I'm familiar with those before me on this case, so I think you know how we generally do these. First of all, is there anyone who is not part of this litigation but needs to be included in this litigation?
No, Your Honor.
Excellent. Have the parties conferred regarding the issue or issues related to this case?
Yes, ma'am. May I? Do you mind?
Well,
I'll go ahead.
I was going to say, not exactly. We talked a little bit out in the hall, but there's been no answer from Lewis County yet. They put in something that was stricken for untimeliness, but they actually have not answered to my complaint yet. So.
Okay, but that's not my question.
Okay.
That's okay. So the purpose of this hearing is just to have an understanding of the issues, not necessarily to require any written response.
Right. I don't. It's hard to explain what the issues are, Your Honor, when I haven't received a response from Lewis County to know exactly what their issues are.
Let me try this way, Mr. Green.
Yes.
I've reviewed your complaint, and I think I know what the issue is.
Okay.
So correct me if I'm wrong. You didn't get a response.
That is correct. Yes,
Okay.
Your Honor, I did get a response.
Okay. Is there any other issue?
Well, they hadn't. Well, Lewis County never replied. I put in I filed the.
I'm not going to get into the facts. I'm just
okay.
trying to understand the issue, and I think it's one.
Yeah, that is the one issue.
Okay.
Yes.
Okay, thank you. Are there other issues that need to be resolved in this litigation?
Yes, ma'am. And I think, please correct me if I'm wrong, but to describe what I think Mr. Green was saying the difficulty was, Lewis County has an answer in this case, which it is very close to being ready to file. But I'm a little stuck in that I don't know how to deal with the issue. It's one of the issues in the case because of Lewis County's pending, but not on this hearing, motion regarding the filing date, which Your Honor may or may not have reviewed because it was filed one day too late for this hearing.
Again, I think we're getting into the weeds here. So I understand that this is not as simple as I'm trying to make it, but it's a contested issue as to whether Lewis County responded properly to the request. Is that correct?
Yes, the underlying PRA.
Yes.
It is, I can represent that it will be admitted that Lewis County did not provide.
I don't need to know that answer.
Okay.
I'm just trying to understand what the issue is. And that's the issue, correct?
There is one issue involving the answer, and then Lewis County intends to file an answer which will raise other defenses, which will be, I think, relevant to this court's decision. And that's what I think what each of us has been attempting to address to Your Honor, and I'm sorry if we're not answering the question that you wish us to answer.
Okay. So you're familiar with the court's local rule regarding PRA scheduling conferences, right?
Absolutely, and I'm happy to discuss Lewis County's view of discovery, in-camera review, and things of that nature. I just thought the court wanted a small amount of background on what the legal issues would be that would inform those answers. Thank you.
So one of the reasons I like to have a discussion about this is because often the parties have a misunderstanding of the court's role on these PRA cases. The court will resolve all of the issues identified by the parties in the complaint or the beginning of the PRA case. It is not the court's role if, in fact, the response is not completed or there are other PRA requests or anything else to continue to monitor compliance regarding future actions. The court's role in a PRA case is to resolve as quickly as possible, pursuant to the statute, the PRA issues that have arisen that have prompted the litigation, not to monitor any future issues that come up. That's why it's important that we identify those issues at the beginning of the litigation. And I want the parties to be clear that it is not this court's role to have continued monitoring and compliance regarding future issues, only issues that have already arisen that have caused the complaint to be filed. So for instance, not in this case, I'm just giving a hypothetical. If a requester files a PRA request and an agency doesn't respond, the issue is that the requester wants a response. The agency may have good reason why they didn't respond. It wasn't a request, they don't have a rec, whatever it is, they didn't receive it, all of those things. But the issue in that hypothetical case is whether the requester is entitled to a response. So I don't mean to be oversimplistic. I know there are a lot of issues in this case, but I just wanted to indicate that's why the court wants the parties to identify those issues up front. So in this case, I understand to be the issue to be whether the agency, in this case, Lewis County, responded to the request appropriately. Obviously, if the court finds a violation, the other issue would include potential sanctions for that violation. Are the parties agreed generally that those are the issues that the court needs to resolve?
Yes, Your Honor.
Yes, ma'am.
Excellent. So, are there discovery matters that the court can address today?
I don't believe so, Your Honor, because I haven't had an answer yet, so I don't believe there is, that we can really address those today.
With regard to the issue that Your Honor identified about whether Lewis County responded appropriately, that is the issue, and the question is whether, I try not to get into the weeds since you suggested I should not. Mr. Green articulated to me in the hall when we conferred, as we attempted to do so, that he had difficulty identifying what discovery he might need or his response to Lewis County's representations regarding whether in-camera review would be needed, because he did not have our answer in order to gauge what he thought the litigation would be about. He expressed to me a desire to be able to set this matter over until after Lewis County had filed its answer so that he could speak more intelligently on that subject. If that is what the court wishes to do, and if that's what Mr. Green wishes to do, that is fine with Lewis County. If you would like me to discuss discovery and in-camera review today, I would be happy to do so instead.
Today is the day for our PRA scheduling conference, so today is the day we are going to address those things. I'm happy to schedule other hearings, or the parties themselves can certainly schedule other hearings. But this hearing is set at the court's request, not the party's request, because the court has an interest in resolving PRA matters as quickly as possible. It is not unusual to have a PRA scheduling conference in which the parties have not even spoken to one another yet. But the purpose of this hearing and the quick scheduling of it is to prompt the parties to move the case forward quickly. So we are going to address these matters, and it appears that the parties don't know if there are going to be discovery issues yet, and certainly none that the court can resolve today. Is that accurate?
That is correct, Your Honor.
I think that's certainly accurate from Mr. Green's perspective, and I'm willing to accede to that. I do think that I can alert the court that Lewis County anticipates that in-camera review will be required in this case. Would you like me to elaborate on why that is?
No.
Okay.
We will not address that today,
Okay.
but let me tell you this. In-camera review is extremely rare and can only occur pursuant to court order. So any party requesting in-camera review will have to make that motion to the court, and the court would have to order it.
Okay.
So I want to be clear. The court does not allow parties to file matters. I use air quotes when I say that. Matters cannot be filed in camera or presented to the court in camera or under seal unless there is an order allowing that. Parties get this wrong a lot. And sometimes they file things with the clerk's office, which is a separate entity from the court. So Superior Court and the clerk's office are two different entities. Mm-hmm. And if a party files something with the court clerk, even with the caption under seal, the clerk takes it and files it completely open to the public, unless there's a court order allowing it to be filed under seal. So, I don't know whether I will agree with you or not that matters need to be filed under seal or reviewed in camera. All I know for sure is that that cannot be done unless the court orders it.
Thank you, Your Honor.
Do you need any further direction regarding filing under seal or in-camera review?
The matters that Your Honor would be reviewing in camera at Lewis County's request are already filed under seal pursuant to a court order in a prior case, but would be relevant to this litigation from Lewis County's perspective. Does the court believe that I should file a separate motion seeking a new full-on Ishikawa analysis for the court's purpose of essentially unsealing for in-camera review and reviewing sealed matters in this case? In other words, do you wish me to relitigate the sealing issue in this case for matters already sealed in a previous case?
So I can't give you direction on how you pursue your case.
Okay.
All I will tell you is that this case is independent and has no relation to any other case. The court never reviews matters in other files when it's reviewing a particular case. So the entire record of this case is under this cause number and no other.
I understand. I would be attempting to make sure it was part of the record of this case. So I will proceed appropriately. Thank you, sir. Thank you.
Is there anything else regarding discovery or in-camera review that we need to address today?
No, Your Honor.
No, Your Honor. Thank you.
So I guess I would like to address, before we go to scheduling a hearing, whether there's any possibility that the parties can work together on a resolution of this case.
Lewis County already approached me with, they would like to try to find a resolution to this case.
Absolutely. I anticipate that we will be providing Mr. Green with the settlement offer on next Wednesday by agreement, and then we'll be negotiating and attempting to resolve the matter.
Okay. Would the parties like to schedule a merits hearing in the meantime? And that way we can have that and it can be canceled if it needs to be canceled after the parties resolve the matter.
Yes, sir.
Okay.
Yes, sir.
So, as you both know, I'd like to move these matters toward resolution as quickly as possible. I have some ideas regarding a merits hearing. When I use the word merits hearing, what I mean is a hearing at which time the court will address the merits of the case. As I think you both know, the PRA allows the court to resolve questions of fact by affidavit or declaration. So it's not necessary to have a hearing in which folks testify, but by consideration of affidavits and declarations, the court may resolve factual issues and address the issues in a PRA case. So that is my preference, to have that merits hearing at which time the court resolves the issues. And then if the court finds any violation, a separate hearing would take place regarding any sanctions associated with that violation. Are we on the same page?
Yes, sir.
Yes, Your Honor.
Okay, excellent. So in terms of proposed dates, we could have the merits hearing on August 10th, on August 24th, on August 31st, or on September 14th. Are any of those dates good for the parties, or are you looking at a different time frame?
I'm just looking at his notice of unavailability that he put in with his notice of appearance. And it looks like maybe she could do August 10th.
That's correct. I can do August 10th. Thank you.
So, because of the court's requirements regarding a briefing schedule, if we set it for August 10th, it would be my preference to require the petitioner's brief on July 13th, respondent's brief on July 30th, and then a reply brief no later than August 5th. Are all of those dates in agreement?
May I ask Mr. Green a question?
Certainly.
If you, so I'm going to get our answer to you as soon as possible, so you can look at it. If you decide that you want to do discovery, is that briefing schedule going to be too soon because you're going to be worried about not getting it in time?
I think that, I didn't even think about that. So maybe we could, if that'd be okay, maybe we could do the September. I'm sorry about that, Your Honor. I didn't even think about
You're not on the record.
So,
Are you done with your discussion?
Yes, to put on the record what the discussion was about, I indicated to Mr. Green that if I give him the answer and then he wishes to do discovery, would this timeline pose problems for him because he'd be worried about not receiving the materials in enough time to brief the case adequately. And after that, it's requested that we perhaps do the September date.
So I understand the parties now to be requesting the date of September 14th. Is that correct?
Yes, Your Honor.
Yes.
Okay. So if we set the merits hearing for September 14th, the court's proposal would be to require the petitioner's brief on August 17th, respondent's brief on September 3rd, and the reply brief no later than September 9th. Are the parties in agreement regarding that?
Yes, Your Honor. Thank
Yes,
you.
ma'am. Thank you.
Thank you very much.
Okay.
And I'm sorry for the hiccup in Seattle.
That's okay. So it would be my preference then that if the court finds a violation at that hearing on September 14th, that the court would set a sanctions hearing at the end of that hearing. Does that make sense?
Yes, ma'am.
Is there anything else that we need to address today?
No, thank you.
No, Your Honor.
So I don't know that we need to put anything in writing in terms of an order from today's hearing other than those dates. And I would appreciate if we could do that. I believe that my judicial assistant could put that order together, just having those dates. Unless the parties request that anything else be in that order, then I would ask one of you to prepare it.
No, that's fine with me, Your Honor.
That's fine with me too, thank you.
Very well. The court will issue that order. Typically, we do send those out to the parties, but I just want the parties to be aware it will certainly be in the court file and accessible to you in the court file sometime next week. But it's my intention to get an order out regarding those dates.
Thank you.
Okay?
Thank you, Your Honor.
We are completed for today.
Thank you. Have a good weekend.
Thank you for being here.